Good morning. Captain Matt had retired here with another one of what I hope to be less than 60 minutes Facebook Live broadcast. And I'm coming at it from a very bad viewpoint because I'm already kind of triggered. I was looking through some materials and I was trying to figure out what I was going to talk about today. I was going to talk about the generous Canadian Forces pension because, well, I decided I will talk about it, but I won't make it my only topic. But I'm kind of triggered because I found a couple of things. Yesterday I found a video where I talked to a Veterans Affairs case manager and they lied to me. And I had videotaped it. And I couldn't find it and I had forgotten about it, but it dealt with the fact that if you're medically released as a Canadian Forces member and you're medically released, you're supposed to get things automatically, like the rehabilitation program. And I was told that you had to be, that only applied for the first little bit, and if you applied again later, you had to go through the normal process. But that's not true. All the documents I've seen have said that the programs are designed that if you get out this way, medical release, then this process is what we have for you. And if you follow another form of medical release, a voluntary release or an whatever, there are 5 different release items under Queen's Regulation and Orders 1501. But because you come through one particular gateway, the medical release process, that's your gateway forever. You are never supposed to go through the other one and have to do an adjudication process. That was in a draft manual I found called VPPM5. So that had me kind of triggered. And then that time I was looking through old internal reviews and audits by Veterans Affairs. And I saw one that they did in 2009 on the infernal, as I call it, review process, not internal review. And I saw black and white lies stated there. They said that they based the system on 2 internal reviews and no external review on some kind of health benefits appeal rights. That's not the way it was. They based it on the income replacement service income support insurance plan. So the service income support insurance plan had 2 levels of internal review, so Veterans Affairs copied SISP into law, so they had 2 internal reviews and no external review. Now I get the Sun Life insurance because I used to work for Canada Revenue Agency, and that has 2 levels of internal review. After the internal review, it can get referred to the Board of Management of the Treasury Board, but that's not really external. So that happens very rarely, 5 or 6 cases a year, and in 1 year they reversed 4 out of 5 cases that was referred to them. Now that refutes any position that Sun Life is the actual insurer. If somebody can overturn their decision, they're not the insurer, are they? So those couple of things have me triggered, but let me get back to the generous idea. You see, I had come up with something I thought was very discouraging and very nasty, in that the military has a pension, the Canadian Armed Forces pension, and if the military has a soldier which is subordinate to orders and they send a soldier to war under a principle called unlimited liability. So because the nation sent that soldier to war, unlike a civilian, they don't have the right to refuse dangerous work. Now, the soldier becomes disabled or killed. Now, obviously, if they're killed, then it's the widow we're talking about, not the veteran. So the veteran comes back disabled, and then the military, through the Department of National Defense Service Income Support Insurance Plan, orders them to get the Canada Pension Plan. But the military also often gives them the Canadian Forces Superannuation Act pension. I shouldn't say give because it's their property, but they pay the Canadian Forces Superannuation Act pension. Now, if the Canadian Forces Superannuation Act pension is being paid and the Canada Pension Plan disability is being paid, then Section 15(2)(b) of the policy reduces one for the other. Now, what had me triggered is that nobody should profit on the backs of someone who you caused to become disabled. I shouldn't have to explain that. That's human, that's common sense. God damn it, if someone causes you, orders you into battle, and then you become disabled, they shouldn't save money. I hope I don't have to repeat myself, but I will. They shouldn't save money. I don't care what the public service does. I don't care what the RCMP does. You can't lump everybody together and try to say that this is normal. It is not normal. Okay? So, anyway, that was what had me all triggered the last few days. So I called a veterans organization. I won't name who they were because I ended up getting into about an hour-long dispute with one of the secretaries, workers, whatever you want to call it, at this particular organization. I had spoken to her before, but I had forgotten. And she kept saying things that kept triggering me, like she didn't think that my idea would go anywhere because the public sees that we get a generous pension. Now, we don't get a generous pension, I told her, because if we get a pension because we have money taken off our checks, we are getting a return of our money that we earned when we earned it in the past. And there's no way you can describe a return of your money, your proceeds, as generous. There's no way you can possibly call money that you own, that somebody else is holding on for you, and they give it back to you. You can't say that you did a generous act. Now, why is the government trying to fool us so that a veterans organization wouldn't see my point? She honestly believed it, I guess. Maybe she was cynical because she thought the government was, the public wouldn't put up with it because, they're saying that we get too much money. But the fact of the matter is they've bamboozled people into believing that the government owns our pensions. The government doesn't own our property, our money. The government holds on to it in trust because it didn't pay it to us when we earned it, and therefore it is a fiduciary, and that means they have to look after the pension as if our interests are more important than their interests because they're holding on to our money. So if they're holding on to our money, they can't do something and harm you. So if, for example, I thought of different ways to try to make people stand up and notice this stuff, I said, why should a veteran who went to war for his nation be punished financially by having the reduction of the Canada Pension Plan on the Canadian Forces pension? What way can they justify applying a financial penalty to the veteran who became disabled in service? Now, I'm doing a dramatic pause for waiting for people to think about that. There is no way you can justify it. Now, the veteran that sort of sparked this, I was talking to a Master Corporal Bloggins. I always use Bloggins like we were taught in training, when you want to keep people anonymous. He got a $40,000 bill because they said he owed them because he got the Canada Pension Plan and didn't inform them. And for 10 years, between 2010 and 2020, they ended up saying, well, you owe us 10 years worth of the bridge benefit. I'm struggling not to curse, but go to frack, okay? You have two different pensions. How can you owe yourself when they're holding money in one bank account over on the Canadian Forces Superannuation Act side, and they're holding money for you on the Canada Pension Plan side, and because you take money out of the bank, they then say you owe money to the other bank account? Now that should be absurd. It shouldn't be happening. And I don't know, I'm kind of getting exasperated here. How come I have to keep telling people obvious things? So anyway, generous, there's nothing generous about getting your own money back. I think the government wants a pat in the back, right? Now, one of the things that I was looking up this morning, and I'm doing these things without a script, so bear with me. One of these days, I might try to add somebody too, because it says here, bring them to the camera or something if I want to. Maybe we'll try like a Zoom call one of these days and hear about other people's opinions about what all this is about, and if you agree with me or if you think I'm full of shit. Okay, I don't think I'm full of shit, or I'd shut my mouth and I'd turn off the video and I'd never speak about it. I hate talking in public or doing things like this. So what I'm trying to say is that the government has its own agenda. And now I'll speak to the Infernal Review and I'll tell you about why it has its own agenda. Back in 1995, the Veterans Review and Appeal Board, which used to be a thing called the Canada Pension Commission, was brought into Veterans Affairs as part of a cost savings initiative, they said. They also brought the Bureau of Pension Advocates, lawyers, into the Veterans Affairs Department, and a person in the opposition, and I posted this to my Facebook group, and I put the pictures there as the proof, 7 different pictures from the Hansard, which is the record of parliamentary debate. Why did they violate the no man may judge his own cause legal principle? I thought of this a while ago, an analogy, a way to try to explain this, to teach people about what I'm talking about. You're walking down the road, a fellow comes along and nails you, smacks you with a baseball bat. You go to the police, you get the police to investigate, they arrest him, you go to court, and then when you go to court to see the bastard who did it to you, you look up there and the judge is the one who smacked you in the face or hit you with the baseball bat. How are you going to get a fair trial when you're accusing the judge of being the perpetrator? So the thing about this is when you have Veterans Affairs Canada judging its own cases, like, for example, the internal review cases, where if you don't like a decision on, say, the rehabilitation or the income support or some other bullshit that they have, then you file an internal review. Now, the internal review person is supposed to review the decision of their own people and then render a decision. Now, if you don't like that, you go back and then another person, which the Minister of Veterans Affairs, Kent Hare at the time, when I brought this up to him years ago, I have a letter from 2016 that I intended to do a show about, and I might yet. I'll probably post a picture of it in this one because I'm talking about the internal review, but after in the comments as evidence. So he tried to assure me that, oh, it's still fair because we have a different person at Veterans Affairs that reviews the other person's decision. Has he not heard of a thing called institutional bias? Why should I expect that institution to give a different decision when you have your coworker gave a decision on your decision? You expect each other to cover each other's backs. For them to try to explain that, oh, we can expect fair treatment by having this is nothing but downright garbage. Bullshit. Okay? Now, as an aside, as a point of interest, that does leave the availability of a lawsuit right after those two internal reviews. Unlike a Veterans Review and Appeal Board one, which is a substitute for a lawsuit, you see, that's the difference. You see, they're supposed to be bringing in an administrative form of appeal, which is cheaper than a lawsuit. That's the whole idea behind having a commission, the Canada Pension Commission in the past, and the Bureau of Pension Advocates, just as a matter of trivia. Their job in the past wasn't to help a veteran with an appeal. Their job, they had lawyers being paid to help with the initial application for the pension. Now you ask, I'm struggling with words here. Why should the government of Canada have such a complex form that you had to apply on to get a pension that you need a lawyer to help you fill it out? Now, I would say the government's doing the wrong thing there to have such a complex application that would be necessary. So then they brought them into the Veterans Affairs and they changed their role, and they no longer help people fill out their forms at the beginning. Now, when I was reviewing it in the Hansard, they said that this made sense because if the case went to appeal, the lawyer who'd helped with the initial application would know about the facts of the case. So if you look at it that way, it makes perfectly good sense. Now, in my mind, it seems stupid right at the beginning until someone explains it to me, until a light bulb goes off over my head, and then I say, well, that makes sense. But it still seems to be a waste of resources, which is what obviously somebody picked on, seized upon, to say that the Bureau of Pension Advocates would no longer help with the initial application. Now, the thing is that those two things, and a member of the opposition stood up in House of Commons and said it for the record. You know you're violating the principle of natural justice here. So natural justice is what we're talking about. You cannot have a right without a remedy. You have to have some way to have your redress listened to. And you have to have reasons provided. Baker, Supreme Court of Canada, 1999. So you have the right to be given reasons. You have the right to be heard. They have taken away the right of a disabled veteran in service, to be heard. That's insane. Now, I started a petition on that years ago, and like most things, I found other things and got distracted. But the thing is, we need to fix the system. We need to bring back some justice. We need to have an independent Canadian Pension Commission, which looks after all appeals, and they are not paid by Veterans Affairs. They do not get a pension from Veterans Affairs. And the reason I bring that up is if you exercise financial control over the members of a judiciary or a commission, then you have control over what they do. They would want to keep their master happy, so they might render decisions, or at least there's a fear of that. Now, I'm referring to a case, because I'm not a lawyer, but Valenti, Supreme Court of Canada, 1987, I think, the year. I know it's the Supreme Court of Canada, and it was talking about the impartiality of judges. And how do you do that when they get paid from the government? So the thing is we should be able to expect from our public servants the best possible system, and we should be able to expect them to try to look after our best interest. Now that means they have a fiduciary duty. If you're trying to look after someone for their best interests, and I'll give you an example of that from a case I came across. There was a World War II veteran who suffered from post-traumatic stress disorder, and he couldn't look after his own affairs. So he had a Pension Act pension, and the Department of Veterans Affairs looked after his needs through his pension that they held in trust for him. Now, there was a lot of veterans in that situation, and they filed a class action lawsuit because the government had the money, the property belonging to the veterans, but they didn't give them any interest. Now, when you hold somebody else's money, you have to give them interest. You can't just say, well, I got the money and I'm not going to give you any interest. You have to act with your fiduciary duty and invest it, do something. You have to give them some form of interest to compensate them for their money. So they won at the Ontario Court of Appeal with the Otherson Ontario Court of Appeal case. And then the Supreme Court of Canada, I have a very jaded view, I think they ruled on the side of the government. And they said, although it's very rare, the government can pass laws which expressly takes away people's property without giving compensation in return. Now, I think that was a very political decision, that they threw the veterans under the bus, just like they did in the Equitas lawsuit. The Equitas lawsuit might or might not have won, but it got turned down by the Supreme Court of Canada. I personally think it was a very weak case in the way it was presented. But the case itself, that veterans should be compensated fully and fairly for their injury in service, goes back to compensation principles in the civilian side. And those are principles I know from the Anders versus Grand & Toy case in 1978. They said they're not talking about pensions, veterans' pensions, and other things. They're talking about compensation for injury. So if you take the compensation or payment a veteran gets in relation to their injury, they're not getting a payment in relation to their service. If they were getting a payment in relation to their normal service, that would be income. But if they get a payment in relation to their injury, the event that causes them to become disabled, then quite rightly the government is not supposed to pay someone twice for the same injury. Nobody, according to the compensation principle in the common law, is supposed to get more than what you suffered in injury. You had to prove your damages. But the problem is these people don't understand, I believe, what compensation means. Compensation for your service on a daily basis when you're going to work for your employer and you're healthy is income. If you get the capital C compensation for your injury because during your military service you got blown up, you lose 2 legs or a leg and an arm, or you lose an eye, whatever you lose, your body is capital, and you therefore got a capital payment. Now, they might have made the capital payment in a lump sum, like the disability award, or they might have made the capital payment in a monthly Pension Act pension, but you are getting a capital payment, which is not income. It could be taxed if they tried to find some way to do it under the capital gains rules, under the Income Tax Act, but they didn't, and they tried to illegally classify it as income when it is property. You cannot misclassify something, okay? When you have cases that go to the Supreme Court of Canada, like the Clark versus Clark case in 1990, a divorcing Canadian Forces member who had a pension decided to sue, his ex decided to sue to get the pension as income. The Nova Scotia Court of Appeal said it was income. The Supreme Court of Canada said it was matrimonial property, had to be divided into divorce. Now, because of that Supreme Court of Canada decision in 1990, 30 years ago, the government can't very well say that the Canadian Forces pension is income. It was decided already on the Canadian Forces Superannuation Act itself. It wasn't some other case like the IBM versus Waterman case in 2013 when Mr. Waterman didn't pay a copper into his pension, but because he didn't pay a copper in, IBM fired him unjustly, got found guilty, and they said, we paid all of his defined benefit pension, so we want to take the value of that into account. Greedy bastards. They shouldn't have fired him in the first place. If you didn't fire him in the first place unjustly, you wouldn't have had to pay damages. Now, because they lost the case, they wanted to reduce the pension by the defined benefit pension where Mr. Waterman didn't pay a cent into his pension. The thing about it was the Supreme Court of Canada said although Mr. Waterman didn't pay a cent into his pension, he earned that with his service. His service has value. So because his service has value, he owns that money, and because he paid it, not you, you can't have it. See? So they weren't allowed to take it into account. Now that's a very important principle, because how come the Government of Canada is still taking the Canadian Forces Superannuation Act into account under the Veterans Wellbeing Act regulation, Section 22? They should know about the Supreme Court of Canada decision. They should know about the Cunningham versus Wheeler case in 1994, Supreme Court of Canada. There was people in car accidents that they had their own long-term disability insurances. And the car insurance people wanted to take the long-term disability insurance into account to save the tort damages. Tango Oscar Romeo Tango tort damages. Supreme Court of Canada said, is it income or is it insurance? If it's income, you can take it into account. If it's insurance, you can't under the Bradburn rule. Now, it was determined to be insurance, not income. Now, if the long-term disability people group and individual policies that people get are not income but they're insurance, which is two separate things, it's a binary choice. It's a 1 or a 0. It's one or the other. The Canadian Forces Superannuation Act is either property or income. The Service Income Support Insurance Plan is either income or insurance. Okay? It can't be both. You can't have it that's both fish and fowl. It's not possible legally. Now, all of that ranting and raving, where am I at? I was talking about the infernal review process, as I call it. I never took part. I never appealed, say mine. Okay, my case, they said that I have 5 medical conditions caused by my service in a letter that they have named the Rehabilitation Record of Decision, which is called the RROD. So Veterans Affairs Canada sent me a letter and said that I had ADD, obsessive compulsive personality disorder, depression, anxiety, and vertigo, because I had my military service during my Class A Reserve Force service. Now, I didn't hold a gun to their head and make them write that down. They chose to write that down. So they took the position that I was injured in service, and I was supposed to get the earnings loss benefit, which according to their policy is supposed to relieve the financial pressure while you're in the rehabilitation program. But you see, the rehabilitation program is a fraud. It's fake. There is no such thing as a rehabilitation program. The real benefit that a soldier gets if they get injured in service is supposed to be the money, the earnings loss benefit. Now it's called the income replacement benefit. But I'll refer back to the Anders versus Grandin Toy case again. They said we can't turn back the time and make him whole. The only thing, although it's a poor substitute, is money. The only medium of exchange that can make him whole is to get damages because they hurt him. Okay, so the person that hurt him who was at fault, and again, in a tort lawsuit, you have to have at least 3 things. I mean, I'm spitballing here, but you have to have some event that happened, some consequence of that event, and some damages that suffer from it. Someone runs, I'll give you an example, kind of a humorous example. I was going for a walk back in the late 90s or the early 2000s in St. John's, and I was walking along the street on Water Street, and someone said, "Watch out!" And I was walking by a bus stop, and I looked back, because I thought something was coming, because that was what you do, and somebody backed into me. Now, when the person backed into me, the opposite direction of where I looked at by instinct, they ran over my leg, and there was a print of the tire in my white, beige pants. It never hurt me. It only left the print of the tire in my pants, and I threw them out, but that's what I'm saying. You have to have damages or you can't sue. I wasn't damaged. Right? So you not only do you have to have an injury, but you also have to suffer some kind of financial harm or physical harm that has to be redressed. Anyway, the point about all this stuff is that the government seems to think that it can get away with treating people unfairly. And the lady who was talking about it yesterday, she brought it up with respect to those generous pensions. She said, the pensions are under financial pressure and they could go bankrupt or something. Well, that's not our problem. We don't have the money in our control. The government is looking after our money as a fiduciary. Now, if they don't run the pensions properly, that's their problem. That's not ours. And they are supposed to do a good job of investing it or doing whatever. Now, the thing about it is that, here's a little bit of trivia for you. From whenever the pensions came into effect until year 2000, there wasn't any money in the actual pensions. All the pensions represented was a paper liability, and everybody thinks that the government can't go bankrupt, which is probably not true. There are cases where states or other places have gone bankrupt. So because they think that the government can't go bankrupt, then they haven't actually put away the money for the future liability of the pensions. Well, in Bill C-78 in the year 2000, they decided to set up separate bank accounts for all the pensions. But nobody seems to realize that by doing that, they admitted they were doing it wrong before. Because that's the way it should have been done from the beginning. You are not supposed to just have a paper liability there and say, trust us, we're going to have the money when you need it. That's not the way it's supposed to work. If you take my money, and the money that I was supposed to get when I served, that is my real money that I need to pay the bills, but you passed a law and you said that I had to pay money into that for my future pension. So now you've interfered with my finances, and I don't have money to spend now to meet my present needs. So with respect to that, and I'll do a little segue here, I've been talking to my Member of Parliament, Seamus O'Regan, about this stuff, not him directly. I've only had the misfortune or whatever. I mean, he seems nice enough, charismatic and whatever, but he doesn't seem to want to do anything. But I've been talking to his staffers a lot. So when they announced that they were going to have a small increase to the Canada Pension Plan to make the benefits a bit better, I called up the office there and I said, excuse me, but you know, you shouldn't do this. They said, why not? It's good to have money for the future. I said, yeah, but you also need money in the present. You also need to live now. You can't bank all your money for the future and ignore the now. You have rent or a mortgage, food, gas, all those expenses now. And everybody thinks it's only a little increase, but then some other agency, they increase their premiums or their contributions. It's only a little increase, and then somebody else does it. And you're stuck with all these little increases, and you're drove into the ground by the government. Now, that's my take on it. So I told them they should have left it alone. But the thing is, they have people believing, I think, that you're getting the Canada Pension Plan, you're getting some kind of subsidy or something from the government, some kind of support. The Canada Pension Plan is 100% paid by the contributor. There is not one copper of government subsidy. The government administers it, yes, but the government also takes money out of the funds to pay the people that works there. So in effect, we're subsidizing the government. We're paying the staff that do that their salary, right? That's one way of looking at it. And speaking of which, and I mean, I'm kind of rambling a little bit, and that's probably because I'm triggered and pissed off with all the way they're doing things. I was talking to the Canadian Forces Superannuation Act people the other day because I was pausing with what was going on. I said, listen, do you still do it the same way for the Reserve Force pensioner like myself? Do you still ask the Canada Pension Plan to approve us in order for us to access our property, our Reserve Force pension plan? They said yes. I said, please pass it up the line. I know you can't fix it, but please make a note and pass it up the line, email, talk to your boss or someone, and tell them that this goes against pension principles. This is likely a leeching, a fraud on the Canada Pension Plan, because instead of you adjudicating the people under your own pension plan, you're having the Canada Pension Plan adjudicate people for you. So instead of you expending your own pension money, you're causing us to expend the Canada Pension Plan money. I said, that's not right. You can't do that. I mean, you have to look after your own people. So, like under the Canadian Forces Superannuation Act, there's supposed to be a board that they set up that adjudicates pensions. I don't think they have it anymore. Once upon a time they did. I mean, think about it. Most pensions are automatic, right? You have a right to your pension. Why do you need a board, right? So it's only for disabled people, I believe, that they had it. So they had 1 or 2 or 3 people that were in this board, and they used to adjudicate files, and then they'd award a pension. But normally, pensions are automatic. You have a vested right. They can't tell you no. That's according to the law, the common law and the Income Tax Act regulations and various provincial law about pensions. You can't look at someone who contributed to a pension their whole career and then say, well, sorry, you're not getting your pension. You just can't, okay? But you see, that's kind of what's happening because, again, my mind is all over the place. The Service Income Support Insurance Plan, for example, takes into account the Canadian Forces Superannuation Act pension. However, the government put into the Canadian Forces Superannuation Act Section 83, which denies them the right to do it. So why do the insurers get away with taking into account something where a law says they can't do it? Now, in the common law, you can't do it because of the Bradburn Rule. In the statutory law, you can't do it because the Financial Administration Act Section 67 works with Canadian Forces Superannuation Act Section 83, and the reason I know that is because there was a case went to court. A lady was owed $300,000 in alimony or child support. Her husband skipped the country, and there was only one asset left in the country, and that was the Pension Act under the Public Service Superannuation Act. So they decided to go to court, either the lady or her lawyer or somebody decided to say, let's go get an equitable receivership. Now, I'm not a lawyer, so I don't know exactly what it means, but I guess they could have accessed a pension if the judge agreed. So the Attorney General of Canada intervened in that case and said, you know, Judge, if you decide that that lady is right and you order the government to liquidate that pension, then you will be ordering us to break the law. And then they brought up the Public Service Superannuation Act, Section 10.2. 1010. Section 11.2 is the authority for the Public Service Superannuation Act to deduct the value of the Canada Pension Plan, which, ironically, the government is doing, even though they went to court to say that the lady who wanted to support her family needed the money. They said she couldn't have it. But when the government wants to save money, they ignore Section 1010. See, I got a problem with that. It's called the rule of law. You can't have two sets of rules. You can't have a set for the government that they ignore everything else and a set for everybody else. You just can't. Well, you can't keep sustaining it. Eventually the system will rise up against you and we'll have a revolution. Because when people are treated badly, they react. If you were treated... Here's the example I keep coming up with. If veterans, because that's my main constituency, I try to help. If veterans are being treated fairly, they have no right to complain legitimately. I have no right to make these videos. But if veterans are not being treated fairly, as I keep telling people, then we have the right to air our grievances. Why the fuck should we sit back and take it because we are good soldiers and we're not supposed to complain? Because ordinarily, if you complain about your employer, you can get fired. You have to be loyal to your employer. You can be dismissed if you speak up and up against the employer. Now, with the government, it's a bit harder. But if you speak up, for example, a guy named Fraser tried to blow the whistle on something, but he didn't exhaust all the internal means first. So they didn't back him up. They told him his dismissal was justified because you have a duty of loyalty to your employer. Now, you see, with the military, it's a lot stronger than that, which is why, and I mean, I'm trying to pass on information to people so that they understand the way the system works. In 1980, there was a Supreme Court of Canada called McKay, Supreme Court of Canada, and they said that soldiers are a special class of citizen. Now, people might be thinking, great, they're special. But you know what they were talking about, if I recall correctly? They were special in that they didn't have the same protections as other citizens, and they had to be subject to a more strict code of service discipline than a civilian has to endure. So, for example, in a military law administration manual I was looking up, they were talking about the fact that a civilian can't be fired for being AWOL. I mean, they might get a fine or something, but you can be dismissed or court-martialed or something if you're absent without leave. So we have all of these strict rules under the Code of Service Discipline, and it's drilled into us in our training and our experience, and we're told it matters. Like if I look at a court-martial, all the different things I've looked up, they would talk about someone who defrauded the system and got caught and court-martialed. And they'd say, Master Corporal, Sergeant Bloggins, he is a vile person. I mean, I'm reading between the lines. They say it nicer than that. But he betrayed the trust of his comrades. And they'd say they have to depend on him in combat. Say you stole something in the barracks. And they say, you got to trust your fellow soldier. And yet he betrayed that trust by stealing from his squad mates. Squad mates? Well, section mates maybe. Squad is an American term. Canada follows the British system, squads, stuff like that. Sections instead of squads. Anyway, my point is trust is very important. That's one of the things that I meant to put into one of these episodes, but if I cover it today enough, maybe I won't do it in the future. However, I do think about it. I thought about it today, and I said, if I do that, I might miss the person who missed an earlier episode. So if a thought strikes me, I'll probably keep going and tell you about it, okay? So the duty of loyalty is important, but loyalty should work up and down, you see? So you can't be loyal to your employer and then your employer give you no loyalty back. I mean, what kind of bullshit would that be? So, again, I mean, the military ought to be, which is why I called the Chief of Defense Staff's office recently. When I had that thought about the way that the military is profiting by reducing the injured in service veterans Canadian Forces pension by the Canada Pension Plan. Now, it's not always dollar for dollar. Let me explain a bit, and I can't help it. It's the old teacher in me, right? I like to help people understand things. They have a formula in the Canadian Forces Superannuation Act, and it's based on the years of service and multiply it by this percentage. And if you get kicked out medically and you get the Canada Pension Plan later, you'll lose a bigger portion than a person who's kicked out earlier, because the percentage obviously would be higher because it's multiplied by the years of service, right? Now think about that on a systemic and a global scale about justice. Is it better to punish someone financially because they were more loyal to your organization and you stayed there a lot longer? Everything about the Canada Pension Plan bridging amount is garbage, okay? They can try to say, and I think they're trying to rely on, this is my gut feeling, and I think I can use a lot of evidence to bring into play to prove it if I was the prosecutor. I think they're relying on the indoctrination that a soldier endures during basic training, where you had to take a person who has been indoctrinated by society not to harm people or kill people, and you had to break that conditioning down, and you have to tell them, train them to kill upon command. Okay? People who think about soldiering being peacekeeping and stuff, basically you murder for the state. Okay? You murder people who the state says is bad, and you aren't treated bad because, well, you're doing it in the state's best interest. So you had to take someone who was told all their life, don't hit Johnny, and then you had to tell them, well, you can kill Johnny now because, well, we told you. Firing order. Enemy to the front, infantry, 500 meters on your own time, single fire. Something like that. Now, again, it's on command. It's not you doing it individually, which would be murder. If you were doing it for your own reason, it would be murder. But because you're doing it for the country, it's not murder. But you think it sits that well? I mean, I've never been on a deployment. But people do things, and then later it would come back and haunt them, I bet you. Right? So that's probably where we get a lot of that PTSD and stuff. I mean, I've done some looking into it, and I think I have it, but I haven't got the diagnosis. I got 25 medical conditions around me. Some are trivial. Some I've had my whole life, like psoriasis, and some I've got recently. Like in 2007, I woke up one day and I couldn't stand up because the world spun around. Okay, so I had a severe case of vertigo. 4 days in bed, I couldn't move my head an inch, and I was throwing up. Finally said to the wife, bring me to the doctor. Went to the emergency, and they said at the time that I had a vestibular nerve infection, which I don't think is true. Because when I looked it up, they said your body is supposed to, and a doctor told me later, your body is supposed to compensate when you have one side of your vestibular apparatus in your ear not working. So when I was getting medical release, a little bit of background, I went and got some exams to check it out. I had a CAT scan, an MRI, and an ENG test, an electroencephalogram or something. So they stuck electrodes on my head, and they poured water in my ears and stuff, and they saw where the electrical signals were going back to the brain, and they said one of the ears, I don't even know which one it was, it has to be left or right, one of them is not sending any electrical signals to the brain. Now, how that happened, I don't know. I don't know if it was because of an injury on a basketball court, which ordinarily you might say is not you're not in service, but I was training to stay in shape, and I was at the base playing with other soldiers, and I got hit in the head, and that could have caused it. And I might have had an infection, but I don't know. It's an internal thing, and all I know is I woke up and I couldn't stand up, and I still can't hardly stand up sometimes. So I've got that problem. But the thing is, it might be or might not be, and that brings me to, say, benefit of the doubt. The government often says it will give veterans the benefit of the doubt until you put in for something, and then all of a sudden they want scientific accuracy, right? So in their mind, I've come to the conclusion that unlike the Snell versus Farrell Supreme Court of Canada case in 1995, which was about medical malpractice, and they talked about the medical malpractice and the fact that some people thought you had to have like 100% accuracy. They said, no, it will be determined on the basis of normal common law decisions, that if it's 51% in the judge's mind, that one party is right and the other party is wrong, then he will rule in that favor. Now, Veterans Affairs operate in the same system. They shouldn't be trying to make us do 100% accurate diagnoses and stuff. I'll give you an example. You get accused of murder, and you go to trial. Society has to prove beyond a reasonable doubt, not to scientific accuracy, that you did that crime. And I'll give you an example of that from my readings again. Guy walked into the police station up in Alberta, I think it was, or BC. He had a bit of blood on him, and he said, come with me. They said, boy, what's up? He just said, come with me. They kept asking him, he kept ignoring them, and they finally went with him, and they found 4 dismembered bodies at the farm he brought it back to. So they charged him with murder. But when it came to trial, they said that he had the right to silence. So the police can't make him talk if he just wanted them to come with him. They couldn't read into it that he was guilty because he wouldn't answer their questions. So now that case caused me to think, okay, so we have people at the Service Income Support Insurance Plan and the Department of National Defense and Veterans Affairs asking us questions all the time, driving us up the wall. But if we were accused of murder, we could keep our mouth shut under the right to silence. So what makes them think that they can do that, force us to answer, when a much higher crime, murder, doesn't require someone to answer, because the person is not supposed to implicate themselves under the Charter of Rights and Freedoms? So what makes them think that they can force us to do everything they say? Now, the reason I bring that up is because of things like they sent me a form called the Earnings Loss Benefit Application Form. I was reading this morning in a review of some of those programs, it said that's automatic, that if you get approved to the rehabilitation program, you will be automatically approved to the Earnings Loss Benefit program. But you know, I didn't get any money. Why didn't I get any money? They sent me the form back and they said you didn't fill it out properly. Why did they say I didn't fill it out properly? Because I knew too much. They asked me questions on the form, and I've posted this online. You can see it, what I wrote. I can't remember the exact words, but I told them they couldn't take it into account. So I was getting the Public Service Superannuation Act. What relevance did that have to the Canadian Forces or Veterans Affairs or anybody? None. I was getting my Sun Life insurance through CRA. What business is that of theirs under a thing called privity of contract in the common law? But they sent the form back to me and said that I didn't fill it out properly, and therefore I never got the money. Now, I was pretty goddamn sick at the time with diabetes at that time. Came up new. That was one of the new 25 conditions I got wrong with me. And I never followed up with it. Plus, my inherent distrust of a situation where I can put in an appeal, I can be right as rain, and they will deny me simply because they want to save money. Okay? If the payments are supposed to be automatic, they hate it, because if it's automatic, that means they have no control. Do I have to explain that to anybody? People want to have control. Whenever they talk about you're eligible, this is one of the things I said to somebody the other day, and I don't remember who. I said, listen, does the word entitle, like you're entitled to a Pension Act pension if you get hurt in service when you're under that coverage, is that a stronger word than the word eligible? You're eligible for financial benefits under the new Veterans Charter if you become injured in service. Now, I have my opinion, and that is I would rather be entitled to something than I would to be eligible, but it seems to me that they would have the right to tell me no for some unknown reason. So I hate that word, and I think it's a dilution of the benefits that we have. And that's another word I hate, benefits. Okay, if you get paid money, people think it's a benefit automatically. But if I say I gave up my right to sue for a Pension Act pension, or the right to sue in workers' compensation, now I gave up something in a quid pro quo compromise. So don't go trying to tell me I'm getting a benefit. And if I get my Canadian Forces or Reserve Force pension plan or my public service pension plan, and I contributed to it my entire career, and then you give me my money back, don't tell me I benefited from getting my own money back. I'm sure I did, but I also could have benefited if you hadn't took it out of my pay in the first place and put it away for the future. Okay? So, you get my drift? I mean, a benefit is not a benefit until you actually see something that is to your benefit, to your advantage. I looked that up. Okay? A benefit has to be something that is to your advantage. And the Appeal Supreme Court of Canada said an incontrovertible benefit is a benefit such as the receipt of money. Because usually, that's obvious to everybody that that's a benefit to someone. But I was thinking the word usually is very important, because they didn't say it always is. It usually is. So if I get a receipt of money because I got injured on the job, a civilian, and some of the people watching are civilians, didn't have any military experience. I've been taking aim at workers' compensation as well as Veterans Affairs, and I'll probably do a broadcast on that in the future, but I'll give you a teaser now. Workers' compensation is governed by what they call the Meredith Principles. It comes from the 1920s, and a judge up in Ontario called William Meredith. So these principles are, there's supposed to be one organization that does the administration of the compensation system. The employer is supposed to pay the premiums entirely, and not one copper come from the injured worker. And the injured worker gives up the right to sue in exchange for this compensation. Now, that's 3 out of the 5. It's not bad off the top of my head. Look it up in my Facebook groups for if you want to see the other two. They're all supposed to work together. You can't have one without them all. So if you get injured on the job and then you go to workers' compensation, there's a 96 to 98% chance of approval, which is the way it's supposed to be. There's not supposed to be many people that get injured on the job and then not get workers' comp. But when you get the money from the workers' compensation system, don't think you're getting a benefit. It's something you're getting because you paid for it, with the right to sue being exchanged for the right to administrative compensation instead of a lawsuit. That's it. Now, I'll give you a tiny bit more because it's in my head. In the old days, there was a fear that companies would go bankrupt or people would not get their money because companies or employers would try every trick they could to try to say they weren't going to be responsible, that they did something at fault. They used to blame other employees. Now, if another employee harmed another employee, then the employer wasn't at fault. You couldn't sue if your coworker hurt you on the job. If their negligence caused you injury, you had no cause of action against the employer. So, you might not hear this from me very often, but this was a good compromise, okay? It simplified the process. It made it simple. If you are on the job and you get injured, you are automatically entitled to workers' comp. Now, over the years, the workers' compensation system has been diluted. In 1998, the Newfoundland government brought in a Canada pension plan reduction. To that, I say the same thing as the member of the House of Assembly said in the Hanford record. It was theft. You're taking the money that belongs to the injured worker and you're reducing the liability of the employer who pays all the premiums. Okay? So people might just say everybody does it, that's just normal and whatever. But you see, the Canada pension plan is not income. It's property and it's insurance. Okay? Gill Supreme Court of Canada, 1973. It's a non-indemnity insurance, which means it doesn't compensate for anything. You don't have to be at work to get it. You can have a 2-year period between the 4th and the 6th years where under the minimum qualification period you can get it, and it has nothing to do with work really. The deductions are taken off your check and sent to the Canada pension plan people, and that's what I used to do at Canada Revenue Agency. See, I think that's one of the reasons why I think I got a handle on all this stuff, is that this was my bread and butter every day for 10 or 15 years, right? I was doing personal income taxes for a while, but I was doing the payroll taxes, including the statutory amounts for the CPP and the EI, for at least 10 years. And I was calling up employers and haranguing them to try to get them to send the money in and saying things, that you can't use that money that you're taking out of the employee's check for your benefit, for your cash flow, when you're supposed to remit that to the government, because that's money held in trust for their Canada pension plan when they get retired, for their employment insurance if they get laid off, or their taxes at the end of the year. And then after that rebuke, hopefully they'd pay. But I was one of the easygoing collectors, by the way. I mean, other people were threatening and doing all kinds of stuff, but I was permanent. So, I was just trying to talk them reasonably into doing it, trying to engage their conscience and saying, this is not your money, okay? You want a legal reference again? Because by now you probably expect it from me, to Sparrow versus Royal Bank of Canada versus Sparrow Electric, 1997 Supreme Court of Canada. They were talking about the trust monies that were deducted off a payment for an employee, and the company had gone bankrupt. So the bank looking after doing the receivership wanted to take the monies, wanted to pay the creditors before it remitted money to the government for the EI and the CPP and the taxes and stuff. And it was said to be a statutory trust, but it's being held in trust for the worker, not for the government. Now the government is us, so it's splitting hairs. But I know when I work with CRA, people would always talk about, you owe the government this in trust, but really the government holds it in trust for the person, and we needed to get the money to hold it in trust. And that was why we'd be out down their throat all the time trying to get their money. But anyway, I don't think I'm going to do my bad fate thing. I've probably been talking long enough. I'm looking at the time here, and it's about 50 minutes. I'm trying to think if there's anything else because, well, shag it, I'll do one quick bad faith one, and it'll be my favorite one, taxes again. And I'll link it to the lady I spoke to at that veteran organization. When I was having that 50-minute argument with her, I explained to her how the government decided in the past to try to make pensions enticing to people. So people would want them for their retirement. Employers might want them. So the government made the contribution a tax deduction. So when you're working or serving, if you have a pension, a registered pension plan, you can claim the deduction of the pension contribution. Now, my first comment is this: common sense, because you did not receive and enjoy that money. That money was listed on your pay stub, on your T4, but you never actually saw that money. Now, there's a principle from a 1972 Supreme Court of Canada case about taxation that said in order to be taxed on a receipt of money, it has to be kept and enjoyed. If you get money and somebody got a claim on that later, that's not your income. You might have to give that up for some reason. So you had to have 100% ownership of that money in order to be taxed. Now, I bring that up because of the CISIP clawbacks and Veterans Affairs clawbacks and other stuff. They claim, or Master Corporal Bloggins, who got the $40,000 bill, they claim he owed money and he has to repay it. But that means it wasn't his property according to them, so that means it shouldn't be taxed, because it wasn't clear that he had that money and he kept and enjoyed it. And one other point, the Finance Canada people do a tax expenditures report, and they often put in there things that, like the Pension Act, that they could gain $210 million or something to if they decided to tax it instead of leaving it as a tax-free payment. Now, they said that they could tax pensions while they're being held, not when you're actually drawing the money and they're losing this much money. They said that we could tax it at the beginning when the deduction is made, and we could get this much more tax revenue. Well, as I explained to the lady at that veteran organization, if you decide to tax the money on the contribution, you can't tax the pension when you pay it. That's clear. Okay? So if you tax it at the end, you can do it that way, and then you have to have it tax-free at the contribution stage, and you can't tax in the middle, because, again, you're violating that principle. Once you tax something once, you can only tax something once. Once you tax something once, there's a principle that you can't tax something twice, called the principle against double taxation. So, again, with the bad faith thing, let me tell you about the CISIP programs. The CISIP program has a long-term disability insurance where the government taxes people 4 times. Okay, first, they charge taxes on the T4 reported income when the premiums that the government paid in their behalf were already included in that. They're not really paid over and above. They're not really fringe benefit. They're not really a fringe benefit. They're really included in your taxable income. The reason I say that is the government has a thing called total compensation. You can't claim on the one hand that the average employee for the government, the public servants, gets $142,000 a year when you count all the things like the employer part of the CPP, the employer part of the EI, the other part of the dental plan, and all these other things. You can't count that as their income and report it to the public as total compensation and then say, on the other hand, we're giving you this money over and above your regular salary. I think I'm right. Secondly, they charge retail sales tax on the premiums. Now, the provinces collect taxes. It's been taxed once. You can't tax it again on the income tax side. Thirdly, they in 2013, they decided to tax it on the premiums. When some employer pays a premium on behalf of an employee, CRA in its infinite wisdom in 2013 said that they're going to start taxing premiums. But they never seem to consider about the fact that you can't tax the insurance then. You can't have it both ways. So the fourth one is under Income Tax Act Section 61F, where they tax it when you become disabled. So the other ones are before disability. On your T4, when you're still serving, you're still healthy. And anyway, you get my point. The retail sales tax, you're still healthy. On the taxes side, well, no, then you're disabled. Anyway, my point is you're not supposed to tax people 4 times. It's highly unjust. And, before I go, I'm going to make this my last point. And thanks for listening or looking on, people. And hopefully, if I get some... Oh, and I'll mention my tooth thing. Someone said, pay some money to get your teeth. Listen, if I was concerned about my looks, I wouldn't be doing these. I've made hundreds of videos, and I have a thick skin. I'm not worried. I want substance over form. I want things to be fixed. But anyway, so, oh, the thing I forgot about my last broadcast, I was trying to remember what Tom Anderson, what the issue was. It was called the qualifying retroactive lump sum payment. So the government brought in a thing that looked good on the surface. They brought in a thing that said if you get a lump sum in a year, that instead of having a high marginal tax rate, we're going to let you spread it over on a T1198 form and let you put it on different years and get a lower tax break, pay lower taxes in the end. But then some enterprising fucker decided to put Treasury bill plus 2% compound daily interest to compensate the government for its loss of time value of money and taxes that were not paid in the year that it was due. Now you can't do that. You can't, on the one hand, say that you're going to do this, you're going to do something to help people and give them a break when they get a chunk of money, like in a pay employment equity thing where the women were getting paid less, or in the assisted class action lawsuit where people got a lump sum that was pretty substantial, and then on the other hand, do something to claw that money back. It doesn't meet the intent of the program. When they brought the program in, it was supposed to help people, not hurt them. How can they get getting away with this? So we need somebody to investigate that, and it will help all civilians and veterans who got a lump sum and ended up having to pay tax on it. Anyway, I'm going to call it quits on that note, but hopefully I make these things a little bit enjoyable. And if you have any suggestions, one of these days I might try to upgrade my system and get a better camera, I don't know, a studio or something. But another thing that occurred to me is I'm getting tired of all this talk and no action. So I might start a GoFundMe or something and try to find some lawyers and sue the shit out of these pricks and take them to court. The only problem is I don't really trust the system that much. Like that Arthurson Supreme Court of Canada case in 2003. They should not have said the government has the right to take people's property without compensation. Tell me that's not true. I mean, if they were building a road, I'll keep talking if I don't watch it. If they're building a road and they decide in the public interest to expropriate your land, they need to take a few feet of your land because it's in the public interest. They can't then turn around and say, we're not going to pay you. What kind of bullshit is that? It's your property, it's your own, you own it. They needed it, but they had to give you something. Now, you might not agree with what you get. That's an entirely different matter. But if you get some form of compensation, you can't then say that they took it from me without compensating me. And what the government did to the veterans, first of all, I'll mention one other thing. They passed a law under the Crown Liability and Proceedings Act, section such and such, that said they wouldn't pay any interest prior to 1991. Now, what the fuck do they think? That they can pass a law that can deny people to get their right to their property? Because pensions being held in trust have to give up interest. Interest is property. Property is under the Property and Civil Rights under the Constitution Act, section 9213. So it's a provincial matter. So the federal government cannot pass the Crown Liability and Proceedings Act, section such and such, saying that they can not pay interest, which, by the way, because again, this stuff keeps circling around my head, under the new Veterans Charter, they have a clause in there that says they will pay no interest. No interest to a veteran. Think about that. That's insane. You can't tell a veteran who you approved 10 years late, here's your money, but there's no interest on it, because then you're ripping them off of the time value of the money. So that needs to be struck down. Now, that's where I'm coming from if I do start a GoFundMe, which sounds to me to be a lot of work and stuff. Because, I'm just hoping the government will wake up and eventually start doing things right. Now, there's another option. I was thinking about doing things on a public interest basis. If you can convince the judge that you're acting in the public interest, then he can order the government to pay your legal bills. So, I'm hoping, here was my plan when I started, but I keep getting distracted. Ask for a lawyer to do it pro bono. Ask a lawyer to try to get us public interest standing. And if we got to, do a contingency basis like 30%. Something about me, I'm frugal. I hate giving up anything to the lawyers. Right? Why should we have to give up 30% of our winnings if we take the government to court when they shouldn't have done it in the first place? Okay? To me, it's entirely unjust to give up any part of your winnings. To go to court, win, and then have to give up some to somebody else. Now, that's not to say in a normal situation a contingency fee is bad, because if you're a poor person and the only way you can get a case heard in court is to hire a lawyer on a contingency basis, then it's good. But in the case of a veteran disabled in service, look at the Bureau of Pension Advocates. The government's principle is the government will provide a lawyer free of charge. Then why do we have to pay for our own lawyers when we take the government to court? I'm going to end it on that note, and I really hope this will start snowballing. I mean, I shouldn't be begging for more viewers and begging for this stuff to get out, but it should have never happened. And we need to spread the word and make it go viral, make these son of a bitches get held accountable.